Assalamualaikum and a very good day. You are tuning to IP News Tonight with me, Nursyahirah Binti Zakariah. Today's discussion will be focused on the liability of ISP Internet Service Provider for infringement of copyright, a comparative study of governing legal framework in Malaysia and United Kingdom. We will continue our conversation with the cases to support our discussion today. That's coming up.
The global advancement of the Internet provides many opportunities to people worldwide in various ways. The Internet has played a significant role in doing things in many aspects of our society. The growth of the Internet also led to the development of Internet Service Providers (ISP) all across the world, including Malaysia and the United Kingdom (UK). ISP is a company which offers Internet access and services to individuals and businesses. In Malaysia, the ISP is governed under the Copyright Act 1987, while in the UK governed by the Copyright Designs and Patent Act (CDPA 1988.
Thank you, Ms. Arisya, for the explanation on the overview of our discussion today. So next, we're going to discuss the Malaysian law in regard to the ISP liability to copyright infringement in Malaysia. Under the Copyright Act 1987, the type of ISP can be classified into two categories as per Section 43B of the Copyright Act 1987. The ISP falls under subsection A has a minor obligation as their function is only in technicality. Meanwhile, the type of ISP that fall under subsection B has more major duties in this category, especially regarding the notice and takedown procedures. Meanwhile, under the Communication and Multimedia Act 1988, Section 6 classified the services provider into four categories, which are Network Service Provider (NSP), the Network Facilities Provider (NFP), the Application Service Provider (ASP), and the Content Application Service Provider (CASP). For the example of this type of ISP, the table on the screen display can be referred to. Now we come to the duty of the ISP in regard to the notice and takedown procedure. Under the Copyright Act, the copyright owner may notify the ISP relating to the infringement of the electronic copy on the ISP network. The ISP then has the duty to remove or disable any access to the infringing electronic copy on their network within 48 hours. However, the person who has the electronic copy of work removed or access denied to that particular work can issue a counter notification to the ISP. The ISP then has to restore the electronic copy or enable access to it. Furthermore, the ISP is obligated to inform the issuer of the counter notification that the material will be restored within 10 business days. Nevertheless, the ISP can ignore the counter notification if the copyright owner has filed a court order or injunction against the person who committed the infringing activity. On the other hand, the SCMA also has provision that specify the duty of ISP. It highlights the obligation of the ISP in their best ability to prevent the four categories of ISP that we mentioned before from being used to commit any offense under the Malaysia law. In addition, the enacted Communication and Multimedia Content Code can be referred to in establishing the duty of ISP for copyright infringement. Part 5 of the Content Code vested the obligation on the ISP listed to block and remove prohibited content involving infringing materials upon receiving complaints of such content. There are several situations whereby ISP may be exempted from liability. This also can be called as a safe harbor of the ISP. Section 43C until 43F of the Copyright Act explain the situations where ISP may be exempted from liability. The details on the situation are as per the display on the screen. However, what I can simplify is that the ISP will not be held liable if they have complied with the notice and takedown procedure under Section 43H of the Copyright Act. If such copyright work is transmitted through its primary network without any modification done by the ISP and the ISP did not receive any benefit for such infringing material or activity on its networks, the ISP will not be held liable. In other words, the ISP cannot be said to be liable on the ground that they are providing a facility and a person has used that facility to perform the infringing material or activity. So next, on the penalty and damages under the Copyright Act 1987. Failure of the ISP to execute their duty under the Copyright Act can amount to a fine not less than RM10,000 and not more than 500,000 ringgit or imprisonment for terms not exceeding 5 years or both of them. Any person making false notification per Section 43H of the Copyright Act 1987 is said committed an offence under Section 43I of the Copyright Act 1987. The offender may be subjected to a fine not exceeding Rm100,000 and imprisonment not exceeding 5 years or both. The offender also must bear responsibility to compensate any person who suffered from losses and damages as a result of making the false notice. So, Ms. Arisya, I have a question in regard to the UK provision or that govern the liability of the ISP in copyright infringement. Maybe Ms. Arisya can explain a little bit regarding this matter.
Thank you so much, Nursyahirah. So now I'm going to talk about the ISP's liability in the UK. In the UK, the 6 largest ISP used by many people are companies like British Telecom, TalkTalk, Virgin Media, O2, Sky and Vodafone. These ISPs company can see growth well because they are among the companies which provide high levels of customer service protection. However, with the rapid growth of users of the ISPs, these companies are also beginning to be exposed to liability towards copyright infringement. Moving on, we are going to discuss about the provision regarding the liability of ISPs in the UK. Firstly, Section 97A of CDPA 1988 provides that the High Court has authority to issue an injunction against a service provider who has actual knowledge that another person is using their service to infringe copyright. The film and music industries have used Section 97A to force ISPs to block access to infringing websites. Next is Section 18 and 19 of the Electronic Commerce EC Directive Regulation 2002, where it provides both provision allow ISP to restrict access to distribution infringing works as soon as the copyright owner notifies them. ISP can take this step to avoid being charged with copyright infringement. However, it should be noted that access should be restricted immediately after being notified. The question is, what is court's injunction? So court injunction, known as website blocking order WBO, basically it requires ISPs to block access to websites that host infringing content. WBOs are an effective and valuable tool for intellectual property rights holders seeking to enforce their rights in the context of the online world. WBOs have now been granted for the following types of platforms: film and music ripping sites, website advertising and selling counterfeit goods, live stream broadcasts of sporting events, and sites hosting user-submitted Pirate Bay filings. One of the issues pursuant to Section 97A is the Nintendo Switch against UK's largest ISPs. Nintendo has obtained a High Court injunction against 6 ISPs in an attempt to prevent Switch games from being illegally downloaded. It was acknowledged that the domains in question provided Nintendo copyrighted content and that majority of downloads came from the UK. The court determined that the sites infringe of Nintendo's copyrights in the UK because it was been communicating to the public.
Thank you, Ms. Arisya. We will continue our discussion on the factual situation, specifically in regards to cases about the liability of ISP in copyright infringement. I hope Ms. Alice is ready. And now I pass the floor to her.
Thank you, Ms. Shahira. Hello, I am Izzati and I will briefly explain some of the related cases for ISP and copyright infringement. Firstly, the United Kingdom case, which is the 20th Century Fox Film Corporation against British Telecommunication PLC. In this case, respondent has breached the copyright of the applicant's work by providing it on one of their websites without applicant's approval. Applicants sought an injunction that would have the effect of preventing the respondent's subscribers from accessing the website. The respondent accepted that it was a service provider within the meaning provided under the law. However, respondent argued that the court had no jurisdiction to grant the order sought by the applicants. The court allowed the application and granted the injunction order claimed by the applicants. The court reasoned that the access providers who merely enable their client to access the internet still provided a service that is capable of being exploited by a third party to infringe copyright. Lastly, the Singapore case, which is Disney Enterprises Inc. and others against M1 Limited and others. In this case, defendant has infringed the plaintiff's copyright works. Thus, plaintiffs claim for blocking orders from the court. They require the network service provider to block their subscribers' access to a few online locations which infringe or facilitate infringement of copyright. The plaintiff sought 2 types of orders. Firstly, an order which requires the network service provider to disable their subscribers' access to the fully qualified domain name FQDN listed by the plaintiffs. Secondly, an order requiring the network service providers, upon notification from the copyright owner, to block any other FQDNs which are not listed in this case if it was discovered that the website had also infringed the copyright. The defendant did not raise any objection to the plaintiffs. Thus, the court held that the main application made by the plaintiff was granted. while the dynamic injunction was also granted but on certain modifications. In conclusion, Malaysia and United Kingdom have their own specific legal framework when it comes to the issue of copyright infringement. These two countries refer to international legal framework provided by the International Convention, which is the Berne Convention. Thus, there might be laws that are similar to one another, but there are still certain differences. From our view, in Malaysia, the cases regarding ISP liability are rarely discussed, but in the UK, there are many related cases that can be found. This is maybe due to the growth of the music and film industry in the UK, which exposed to all users globally and at the same time make it easier for piracy to happen. Nevertheless, one of the loopholes in Malaysian law and UK law is that there is no duty of the ISP upon encountering infringing materials on their network to take down such materials immediately. They are obliged to do so only when the copyright owner notifies them regarding the issue.
And that's all we have for you on IP News tonight. Get a latest news on the current issue relating to IP from our website ipnews.com. I'm Nursyahirah. I see you next week.